Hello, this is Zarina Ocampo here with Armando Carrillo and Andrew Van Gansen. Our Chief Justice is Edward White, and our landmark Supreme Court case is Texas v. Johnson. Edward White was born on November 3, 1845 in Lafourche Parish, Louisiana. He was raised by a sugar planter and a lawyer. He grew up as an Irish Roman Catholic. He was fortunate enough to grow up in an upper class with a wealthy family, with his mother Catherine Ringgold and his father Edward White. He traveled north for college and enrolled briefly in Mount St. Mary's College in Emmitsburg, Maryland, and then went to Georgetown College, which is now called Georgetown University in Washington, D.C. His education was cut short due to the Civil War, where he enlisted in the Confederate Army in 1861. He was later admitted to the Louisiana Bar in 1866. White studied law in Tulane University, then eventually went into politics. White was elected as a Democrat to the state Senate. In 1878, at the age of 33, he was then appointed to the Louisiana Supreme Court. Later on, he was removed from the court because he was not able to meet a new minimum age requirement that was enacted after his appointment had actually begun. After 10 years, he went back into politics when he was elected by the state legislature to represent Louisiana in the U.S. Senate. White was appointed by President Grover Cleveland, which was a surprise because Cleveland wanted to appoint New Yorkers to replace Blatchford, who had died, but the New York senators were his enemies. Cleveland then decided to appoint White because senators would never disapprove of their own kind. White was commissioned on February 19, 1894, and was sworn in on March 12, 1894. He was later made Chief Justice by President Taft. A landmark case that White ruled on was Gwin v. United States. It included state constitution provisions which had made qualifications for voters. The grandfather clause exemptions to any literacy tests were considered unconstitutional. Another landmark case that White ruled on was Wilson v. New. Edward White sustained the Adamson Act of 1916, which fixed minimum wages and the maximum hours for railroad workers. The military enrollment was upheld in the selective draft law case, which was known as the Arver v. United States of 1917. In the United States v. American Tobacco Company, the case deals with the limits of trade and make an effort to control the tobacco business in the interstate commerce within prohibitions of the Sherman Antitrust Act of 1890. During Civil War, Edward White was held prisoner by Union forces and was kept prisoner until the war ended. White was the first Southerner since Roger Taney to head the Supreme Court. Even though White was appointed by President Cleveland to the U.S. Supreme Court, he stayed several weeks in the Senate because he could not be persuaded to leave. He wanted to make sure that the Wilson-Gorman Tariff Act was passed. The bill protected the domestic sugar producers. He wrote the Rule of Reason decisions, which differentiated between legal and illegal business elements in the cases that were against the American Tobacco Company and the Standard Oil Company in 1911. In 1916, Edward White supported the constitutionality of the Adamson Act. It established an 8-hour day for railroad workers. He was known as the 9th Chief Justice of the United States, who served from 1911 to 1921. He served until his death in Washington, D.C. on May 19, 1921. Edward White is buried in Oak Hill Cemetery, which is located in Washington, D.C.
All rise for Judge Teddy in the case number 1157, the People of Texas versus Gregory Lee Johnson. Sit down.
How, How does the defendant plead?
Not guilty.
Who does the prosecutor call as their first witness?
We would like to call Mrs. Eastwood.
Miss Eastwood, what happened?
Well, Johnson over here decided to one day just get a flag and burn it. Disrespectful.
Why did Johnson's actions offend you?
Well, why not? Figuratively, he burned our nation to the ground. Literally, it was lit.
Were you offended by the actions that Mr. Johnson took?
Why, yes, of course I would be. I mean, how could I not?
We find Gregory Lee Johnson guilty of the desecration of a venerated object in violation of Texas Penal Code annotated 42.09A3, sentenced to 1 year in prison and fined $2,000. Dismissed.
Mr. Johnson would like to appeal his conviction to the 5th Court of Appeals of Texas.
You are guilty to the 5th Court of Appeals of Texas. You lost.
We, the Texas Court of Criminal Appeals, have reviewed the decision. The court has overturned his conviction. We have stated that the state of Texas cannot punish Johnson for burning the flag because the First Amendment to the United States Constitution protects such activity as symbolic speech. We have concluded that the flag burning in this case did not cause or threaten to cause a breach of the peace. The state of Texas asked the Supreme Court of the United States to hear the case. We, the Supreme Court, have a decision. We have a decision of 5-4 in favor of Gregory Johnson, holding that Johnson's conviction for flag desecration was inconsonant with the First Amendment. We, the court, decided and validated laws against flag desecration in force in 48 of the 50 states.